Look, getting fired is a shock, right? No matter where it happens. But here in Switzerland, the rules can be, well, they can be really confusing and honestly, a little bit scary. So if you've been let go and you're trying to figure out what your rights are, you've come to the right place. Today, we're going to break down the super important concept of abusive dismissal under Swiss law. All right, here's our game plan. We'll start with the basic Swiss rule that catches so many people by surprise. Then we'll look at the limit to that rule. We'll dig into what actually makes a firing abusive, cover the 2 critical steps you absolutely have to take, and finish up with what you might be able to claim. Okay, Section 1. Let's get right into the foundation of Swiss employment law. And you might want to brace yourself for this one, because it often catches people completely off guard.
So does this sound familiar? Maybe you're going through it right now. You get called into an office, told your job is ending, and they give you no real, concrete reason why. It just feels wrong, unfair. And you're left there wondering, wait a minute, can they even do that?
Well, the short answer, believe it or not, is yes. Swiss law is built on this big principle called freedom of termination. And what it really means is that both you and your employer can end the contract anytime for any reason or for no reason at all. The only catch is that the notice period has to be respected. And here's the part that is just a tough pill to swallow. Even if the reason feels completely unjust, totally unfair, the termination itself is still legally valid. Your job is gone. That's the central paradox we have to get our heads around before we can go any further. So, you're probably thinking, is that it then? Game over? Well, not quite. This is where we get to the crucial exception, the limit to that rule. It's the concept of abusive dismissal. Now, let's be clear. This won't save your job, but it is a path to justice. And this is so important to understand. Challenging a dismissal in Switzerland is not about getting your job back. The termination is final. The fight is about proving that the reason you were fired or the way you were fired was abusive. And if you can prove that, you are entitled to financial compensation.
And hey, this isn't just an opinion. It's a core legal principle here. It makes it absolutely crystal clear. The goal is compensation, not getting your old desk back.
Okay, so what exactly pushes a normal, valid firing over the line into a legally abusive one? The law actually gives us some very specific examples, and over the years, the courts have added even more. If you look at the Swiss Code of Obligations, Article 336 to be exact, it lists some real clear-cut cases. Firing someone for their age, their gender, or where they come from, that's out. Same for firing them because they joined a political party, are in a union, or have to do their mandatory military service. The law also protects you if they fire you just to avoid paying a bonus or, and this is a big one, as revenge for you making a legitimate claim. They even have a specific word for it, Rechtskündigung. But the list doesn't stop there. The courts have looked at real-life cases and said, you know what? Sometimes it's not just why you are fired, it's how they did it. A dismissal can be abusive if it's done in a humiliating way, if it's the first move in a conflict instead of the last resort, or if it targets the victim of workplace bullying. It's how the courts step in to protect an employee's dignity. Let me give you a real-world example so you can see how this actually works. This case involved a human resources director, and get this, she had been at her company for 20 years. So after 2 decades of service, she was fired, told to hand over her keys immediately, and then was literally escorted out of the building in front of everyone. The Supreme Court looked at this and said, nope, that's abusive. Why? Because the way they did it created this false impression among her colleagues that she must have done something awful, like steal or commit fraud. And that was a huge violation of her personal rights. This whole idea of an employer's duty of care is huge, especially when it comes to workplace conflicts. I mean, a good employer is supposed to investigate problems, talk to everyone, maybe try mediation. Firing someone should be the absolute last resort. But if an employer just ignores the problem or only listens to one side and then jumps straight to firing as the first and only solution, well, that's when a dismissal can be considered abusive. All right, now we're getting to what might be the most important part of this whole explainer. If you think your dismissal was abusive, you cannot wait around. There are 2 time-sensitive, absolutely non-negotiable steps you have to take. First, you have to object in writing, and I mean a physical, signed letter that you send by registered mail to have proof. An email is not going to cut it. Second, if you and your former company can't work things out, you have to file a formal legal claim with the right authority. Now, pay really close attention to the timing. For that first step, your written objection, it has to be physically received by the employer before your notice period ends. The day you mail it doesn't matter. It has to be in their hands by your official last day. This detail trips a lot of people up. And for that second step, filing the legal claim, you have exactly 180 days. Not 6 months, but 180 calendar days starting from the last day of your employment contract to file your claim. Let me be crystal clear here. These deadlines are absolute. If you miss either one of them, even by a single day, your right to claim any compensation is gone, forever. There are no extensions and no do-overs. Okay, so let's say you've done everything right. You've followed the steps, you've met the deadlines, and your claim is successful. What's the potential outcome? What can you actually get for an abusive dismissal?
The law sets the maximum compensation at a penalty payment of up to 6 months of your gross salary. And it's important to remember, this isn't about covering lost wages. It's a penalty to punish the employer and to compensate you for the injustice of the firing.
But those key words are up to 6 months. A judge doesn't just automatically award the maximum. They're going to do a big balancing act. They'll look at everything: how badly the employer messed up, how long you worked there, your age, your financial situation, and even whether your own actions might have contributed to the problem. So it all comes down to this one crucial question you have to ask yourself. Many firings feel unfair or are handled badly. But was yours just unpleasant, or did it actually cross the legal line into what the law calls abusive? Understanding that difference and knowing the strict steps you have to take, that is your most powerful tool.